Welcome to the Deep Dive, where we take your pile of information and turn it into actionable insights.
Glad to be here.
Today, we're embarking on quite a fascinating deep dive into a crucial area of criminal law. This is especially important for anyone like you, maybe navigating legal principles for exams or practice.
Absolutely.
We've got a comprehensive criminal law reviewer here, focusing on circumstances which affect criminal liability. It's packed with doctrine, jurisprudence, statutes, the works.
Yeah, lot to cover.
Our mission, to really distill the most important nuggets from these sources, give you that shortcut to being well-informed on what can be a pretty intricate topic.
Indeed. We'll be breaking down specifically Article 11 through to Article 15 of the Revised Penal Code. These articles explore situations where an act, even if it looks like a crime, might not actually result in criminal liability. Or, where the level of blame, the culpability can shift quite dramatically.
Right.
And it's not just about memorizing definitions, is it? It's about understanding the nuances, the gray areas.
Exactly. Those nuances can make all the difference. Okay, let's unpack this. Let's see what really stands out as critical for understanding how liability is assessed.
Sounds good. Where should we start?
Let's start with actions the law actually considers lawful under specific conditions, even if technically they look like a crime. These are the justifying circumstances, right? Article 11.
That's right, Article 11. And what's fascinating here, the key takeaway, is that these circumstances mean the act itself is seen as permissible. So fundamentally, no crime has actually been committed.
No crime at all. Okay, so the classic one everyone thinks of, self-defense.
Ah, yes, self-defense, always the first example.
What are the core elements you absolutely need to establish for that?
Okay, for self-defense, there are three essential requisites. You need all of them. First, there must be unlawful aggression.
Unlawful aggression, okay.
Second, reasonable necessity of the means you use to prevent or repel that aggression.
Reasonable means, got it.
And third, a lack of sufficient provocation on the part of the person defending themselves. You can't have started it, basically.
Right, you can't have provoked the attack unreasonably, so it's not just about feeling threatened then, it has to be more concrete.
Exactly, it has to be real. There's a recent case, Camilla v. People, from 2023.
Oh, yes, I saw that one. What did the Supreme Court emphasize there? It seemed quite direct.
Very direct. It made it crystal clear. Actual unlawful aggression must be present. It has to be happening or about to happen. Mere threats or, say, aggression that happened yesterday, that's not enough to justify defending yourself now.
The immediacy is key then.
Immediacy and reality, yes.
Okay, now that brings us to a really important and sometimes quite misunderstood area, battered woman syndrome.
Yes. RA 9262 touches on this, but the key jurisprudence is often cited as People v. Genosa.
The Genosa case from 2004. The court recognized the condition, didn't it? But there was a crucial distinction made.
Absolutely pivotal case. The court did recognize battered woman syndrome as a reality. But here's the critical point for understanding liability. It was recognized as a mitigating circumstance in that specific case, not a justifying one.
Mitigating, not justifying. Why the difference?
The key legal sticking point was the absence of unlawful aggression at the very moment of the killing. The threat wasn't immediate in the way Article 11 requires for self-defense.
Ah, so the strict definition of unlawful aggression wasn't met at that precise time.
Correct. Legally speaking.
But the court did acknowledge the psychological impact, right? The psychological paralysis from the abuse.
Yes, definitely. And this is where the nuance comes in. While it didn't fit self-defense, the court recognized that extreme psychological state due to the cycle of violence. It was considered under Article 13, specifically paragraph 9, analogous circumstances, and 10, passion or obfuscation. So it lessened the penalty.
So it highlights a tension, doesn't it, between the strict legal need for immediate aggression and the psychological reality of long-term abuse. How do we reconcile those?
That's the ongoing challenge for the law. Genosa shows the court trying to find a way, acknowledging the condition's impact, even if it doesn't perfectly fit the existing justifying box. It mitigates culpability.
A really important point about how the law adapts or tries to. Okay, let's move on. Next up, exempting circumstances. Article 12.
Right, Article 12.
Here, criminal liability is negated entirely. But it's not because the act was lawful, like in Article 11. It's different. Why?
It's because there's a fundamental lack of something essential for criminality, usually voluntariness or intelligence, basically intent. The law acknowledges that for a crime to truly exist, you need a culpable mind or a voluntary act. If those are missing, liability just vanishes.
Okay, so the big one here is insanity, a powerful exempting circumstance. What's the standard of proof? What needs to be shown?
Insanity is tough to prove. The defense needs to show, by clear and convincing evidence, three things. One, complete deprivation of intelligence or reason, not just diminished but complete.
Complete deprivation. Okay.
Two, this state must exist at the time the crime was committed, not before, not after, but during the act.
At the time. Crucial.
And three, it generally needs to be proven, often through medical testimony. Expert evidence is usually key.
And there's a specific test now, isn't there? A three-way test.
Yes, that came out of People v. Pena in 2020. It sort of bundles those requirements. Was the accused insane at the time? Is it medically proven? And, crucially, did this insanity mean they couldn't appreciate the wrongfulness of their act?
Couldn't tell right from wrong, essentially.
In essence, yes. A complete breakdown of that capacity.
What about proving it? Has there been any recent development on how courts look at the evidence for insanity?
Yes, actually. A 2024 case, Revised People, is interesting here. The court acquitted based on insanity, and it emphasized that you can look at the person's behavior before, during, or even after the act. This pattern of behavior can help prove that deprivation of intelligence at the critical moment. It's not just a snapshot.
A more holistic view of the person's state of mind around the event. Okay. Next, under exempting. Minority. This is huge, especially with RA 9344, the Juvenile Justice and Welfare Act.
Absolutely critical.
First, how is a child in conflict with the law, a CICL, defined? And what's the absolute minimum age for criminal responsibility?
Okay, a CICL is legally defined as anyone below 18 years old who is alleged to have committed an offense. And the minimum age of criminal responsibility is set at 15 years old. Below 15, there's no criminal liability period. Full exemption.
Okay, below 15 exempt. But what about between 15 and 18? It's not automatic exemption then, is it?
No, not automatic. For those age 15 but under 18, there's another absolutely crucial factor. Discernment.
Discernment. Can you explain that? What does it mean in this context?
Discernment means the mental capacity to understand the difference between right and wrong and understand the consequences of the wrongful act. For the 15 to 18 group, the law presumes they acted without discernment. The burden is on the prosecution to prove they did have it.
So the default is exemption unless discernment is proven.
Correct. If the prosecution can't prove discernment, the minor is exempt.
How do courts even determine if a minor had discernment? It sounds like a really complex judgment call.
It is complex.
Yeah.
There was a case, CICL XXX v. People, in 2023 that laid down some helpful guidelines. Courts look at things like the manner the crime was committed, the minor's conduct before, during, after, their education, their background, even the nature of the offense itself.
So a very fact-intensive inquiry.
Very much so. It raises that tough question. How do we fairly assess a young person's capacity? It's about balancing protection with accountability.
Is there a case that shows this principle in action, where a lack of discernment led to exemption?
Yes. Dorado v. People from 2015 is a good example. In Dorado, a minor was found to have acted without discernment. So instead of facing criminal charges, they were exempted and referred for an intervention program under the juvenile justice system.
Shows a rehabilitative focus. Okay. What about accident as an exempting circumstance?
Accident. Paragraph 4 of Article 12. This applies when someone is performing a lawful act with due care, and they cause an injury by mere accident, without any fault or intention of causing it.
So, lawful act, due care, no fault, no intent.
Exactly. The classic case often cited is US v. Tong Tong, early case. A chauffeur was driving carefully, obeying rules, and someone suddenly darted out and was hit.
And the court said,
No criminal liability, it was a genuine accident. No negligence, no intent, just misfortune.
Got it. Now, irresistible force sounds quite dramatic.
It often involves dramatic circumstances, yes.
Right.
This is Article 12, Paragraph 5. It's when someone is compelled by a force that is, well, irresistible, physical force, usually.
An example.
US v. Caballeros, another old but clear case. The defendants were forced by armed revolutionaries under threat of death to bury corpses. They had no choice.
And the court found them exempt.
Yes, exempt under Article 12.5. The force used against them was so overwhelming their actions weren't truly voluntary.
Makes sense. Similar, but maybe more psychological, is uncontrollable fear, Paragraph 6.
Precisely. Article 12, Paragraph 6, acting under the impulse of an uncontrollable fear of an equal or greater injury. This focuses more on the mental state, the overpowering fear.
Is there a case illustrating this?
US v. Exaltation is a good one. The accused was forced to join the Katipunan, a revolutionary group, under direct and immediate threat of being killed if he refused.
And the ruling?
Exempt. The fear was real, immediate, and uncontrollable, negating his criminal intent. The will was overcome by terror.
Okay, so we've covered justifying circumstances, lawful acts, and exempting circumstances, lack of intent, or voluntariness. Now let's shift gears. What about situations where there is criminal liability but the penalty is reduced? Mitigating circumstances, Article 13.
Right, Article 13. These don't wipe out the crime, but they lessen the penalty. Why? Because the law recognizes factors that diminish the offender's blameworthiness or show a lesser degree of perversity.
So connecting back, the battered woman syndrome in Genosa fell here, right, as a mitigating factor.
Exactly. It didn't justify the act, but the extreme emotional and psychological state was recognized under Article 13. Specifically, it was analogized to passion and obfuscation, which are listed mitigating circumstances. It acknowledged the diminished culpability.
Now, you mentioned earlier a difference between generic and privileged mitigating circumstances. Can we clarify that?
Yes, good point. It's crucial for understanding the impact. Generic mitigating circumstances like voluntary surrender or passion obfuscation are considered when applying the penalty rules. They might lower the penalty within the range prescribed by law.
Okay, lowers it within the range.
But privileged mitigating circumstances have a much stronger effect. They automatically lower the penalty by 1 or even 2 degrees on the penalty scale provided in the code.
A much bigger reduction then.
A significantly bigger reduction. And sometimes they can even change the nature of the crime charged.
Can you give an example of a privileged mitigating circumstance?
Sure. Incomplete self-defense is a classic example. Remember the 3 elements for self-defense. If maybe unlawful aggression was present, but the means used were not reasonable.
Ah, so one element is missing.
Exactly. Or maybe there was some provocation. If most, not all, elements are there, particularly unlawful aggression, it could be considered incomplete self-defense. The People v. ULEP case illustrates this. Unlawful aggression was present, but the policeman used excessive force.
And the essay.
The court treated it as incomplete defense, a privileged mitigating circumstance. It downgraded the crime from murder to homicide. Big difference in penalty.
Huge difference. What about minority? Can that also be privileged mitigating?
Yes, minority is another key privileged mitigating circumstance. Remember the 15 to 18 group. If discernment is proven, they aren't exempt.
Right.
But their age, being under 18, still counts as a privileged mitigating circumstance. People v. Encas confirm this. So even with discernment, their youth significantly lowers the penalty by potentially 1 or 2 degrees.
So minority can be exempting, no discernment, or privileged mitigating with discernment.
Got it. Okay, from reducing penalties, let's flip to the other side. Circumstances that increase the penalty. Aggravating circumstances. Article 14.
Right, Article 14. These signal a greater degree of criminality or perversity in the commission of the crime. They reflect increased blameworthiness and generally lead to a higher penalty being imposed.
There are different types here too, aren't there? Ordinary and qualifying?
Yes. Similar to mitigating, there's a distinction in effect. Ordinary aggravating circumstances increase the penalty, usually to its maximum period, but they don't change the fundamental nature of the crime.
Okay, penalty goes up within the same crime's range.
Qualifying aggravating circumstances, however, are more serious. Their presence changes the nature of the crime itself. They elevate the crime to a more serious one defined in the code, which carries a higher penalty by default.
Can you give an example of how these play out? Maybe a qualifying one? Sure. People v. Cebu from 2017 is a good example. In that case, the circumstances of treachery, employing means to ensure execution without risk to oneself, and nighttime were present. These were held to qualify the killing to murder. Without them, it might have been homicide. With them, it became the more serious crime of murder.
So treachery itself made it murder, not just homicide with an aggravating factor.
Precisely. That's the power of a qualifying circumstance. Others include evident premeditation, cruelty, use of poison, etc.
Now, sometimes special laws outside the Revised Penal Code, can introduce aggravating factors, right?
Absolutely. The RPC interacts with numerous special laws. For example, under RA 10591, the Comprehensive Firearms and Ammunition Regulation Act, the use of an unlicensed firearm in the commission of crime like homicide or murder is treated as a special aggravating circumstance, increasing the penalty significantly. It can even qualify homicide to murder.
Wow. What about, say, drug-related crimes or cybercrimes?
Good question. Under RA 9165, the Dangerous Drugs Act, committing a crime while under the influence of drugs, or if the crime is motivated by drug use or trafficking, can be aggravating.
Okay.
And under RA I-175, the Cybercrime Prevention Act, if you used information and communications technology, ICT computers, the internet to commit a crime, like libel, theft, or fraud, That use of ICT can act as a qualifying circumstance, leading to a penalty 1 degree higher than for the ordinary version of that crime.
So the medium itself aggravates the offense. Interesting. Okay, moving on to Article 15. This one seems unique. Alternative circumstances. They can go either way.
Exactly. Article 15 lists 3: relationship, intoxication, and degree of instruction. What's fascinating is that whether they mitigate or aggravate depends entirely on the context.
Context is everything here.
Absolutely. For example, relationship. If you kill a close relative, that's generally aggravating. But if you injure a stranger who attacked your child, your relationship to the child might be seen in a mitigating light, defensive relative context. Intoxication, if it's not habitual and not subsequent to the plan to commit the crime, it might mitigate. But if you got drunk to commit the crime, it could aggravate.
And degree of instruction, low education.
Low degree of instruction and education might mitigate certain crimes requiring more understanding, but for others, like, say, theft, it generally doesn't have much effect either way. It's very case-specific.
Really highlights how nuanced criminal law has to be.
It truly does. Facts matter immensely.
Okay, one last category. These are quite interesting. Absolutory causes.
Ah, yes, the absolutory causes.
These are situations where an act might technically fit the definition of a crime, but the law says no punishment. Why?
These are intriguing because they often reflect specific public policy decisions, or situations where criminal intent is clearly absent despite the act, or where prosecution is deemed counterproductive.
So the act looks like a crime, but no penalty follows. What are some examples?
Well, one key example is spontaneous desistance in the attempted stage of a felony. If you start to commit a crime, but then out of your own conscience or change of heart, you stop before completing all the acts of execution.
You back out voluntarily.
Voluntarily, yes. Then you're generally not liable for the attempted felony you started. The law wants to encourage people to stop.
Makes sense from a policy view. Any others?
Instigation is another. This is where law enforcement officers actually induce someone to commit a crime they wouldn't have otherwise planned. This is different from entrapment, where officers merely provide an opportunity for an already predisposed person. Instigation absolves liability because the criminal idea originated with the state.
A crucial distinction.
Also, some exemptions under special laws. For example, under the Dangerous Drugs Act, sometimes immunity might be granted to a drug user who turns state witness or undergoes rehabilitation under specific conditions.
So specific laws can carve out these no punishment zones.
Exactly, based on policy goals like fighting larger syndicates or promoting rehabilitation.
Wow, what a journey through these intricate layers of criminal liability, from acts deemed lawful to acts done without intent to all these factors that can raise or lower the penalty. It's so clear the law looks at much, much more than just the act itself.
It really does. Understanding these justifying, exempting, mitigating, aggravating circumstances,
Yeah.
and the alternative and absolutory ones too. It's just fundamental. It shows you how the legal system tries, sometimes imperfectly, but tries, to calibrate justice, not just based on what happened, but why it happened, the full context, the person's state of mind.
For someone like you delving into this, perhaps reviewing for the bar or just needing to understand it, focusing on these distinctions, the elements of each, and how they apply in real cases like the ones we mentioned, that seems key.
Absolutely. Knowing the rules is one thing. Seeing how they are applied by the courts is another level of understanding.
So reflecting on all this, what does it mean for you, the listener, as you grapple with this material? Maybe consider this. If the law makes space for all these nuances, these shades of gray, what does that tell us about the nature of justice itself? Is it always about finding a simple black or white, guilty or not guilty? Or is it this constant, complex process of trying to understand human action and intent in all its messiness?
That's a really profound thought to carry forward. This deep dive, hopefully, gives you a solid foundation, not just for exams, but for appreciating the deep complexity, the challenge, and maybe even the philosophy underpinning criminal law.
We certainly hope this deep dive into circumstances affecting criminal liability has given you a fresh perspective and some powerful insights. We'll catch you on the next deep dive.